Ladies and gentlemen, when I first looked at Stephanie's case, it was clear that the area of law that we had to look at would be under the intentional infliction of harm. The primary case that we have to look at would be the case of Wilkinson and Downton. The facts of Wilkinson is similar to the present case, where the defendant, Mr. Downton, told the plaintiff, Ms. Wilkinson, has a joke that her husband has been involved in a serious accident. As a result of this unfortunate joke, the plaintiff suffered a nervous shock which led her to suffer weeks of illness. The plaintiff sued the defendant for compensation for her illness and suffering due to the false representation made by the defendant. It was held by Justice Wright that the defendant has willfully done an act calculated to cause physical harm to the plaintiff, that is to say, to infringe a legal right to personal safety, has in fact thereby caused physical harm to her. This was further applied in the case of Harvey and Sweeney. Therefore, looking at the present case, it could be argued that Stephanie would have a claim under the rule of Wilkinson. However, the rule of Wilkinson was further developed, which we will now look at. In the case of Wong against Parkside NHS Trust, the requirement for intentional infliction of harm was clarified. First, there must be actual harm. Second, the defendant must have acted intentionally. And third, the conduct must be of such a degree that is calculated to cause harm so that the defendant cannot say he did not mean to cause it. It was further held that the wrongful conduct must cause physical injury as distinct from mere emotional distress, and that it must be calculated to cause the same. Subsequently, in the case of Wainwright and Home Office, Lord Hoffman, who was writing the principal judgment, affirmed that, traditionally, it required proof of actual harm such as psychiatric illness. This was further looked in the case of C&D, where Justice Field said, "It is clear that what Lord Hoffman says that even if an intention to cause harm can be established, the principle in Wilkinson and Downton is only available if the harm suffered is a recognized psychiatric injury. The principle does not allow recovery for emotional distress." Now, the current state of law on both harm and intention was discussed in the case of Rhodes and OPO, a Supreme Court case. The Supreme Court dealt with the correct scope of the tort of intentionally causing psychological harm. There were three key elements. Number one being the conduct element, number two being the mental element, and number three being the consequence element. The conduct element requires words or conduct to be directed towards the claimant which there is no justification. The mental element. The Supreme Court has now made it clear that intention for this purpose is actual intention inferred from the facts in the particular case, and therefore recklessness is not sufficient, though previous authority had held an intention could be imputed as a matter of law, so that even if a defendant did not intend to cause such harm, an intention can be imputed to him if there was a likely consequences. And finally, the consequence element, it's either a physical harm or a recognized psychiatric illness. Therefore, looking at Stephanie's case, does her case satisfy all three elements? It could be argued that her case satisfied the first two elements, which is the conduct and the mental element. For the conduct element to be established, the words and the way Michael conducted himself in front of Stephanie when saying the argument was struck by a lorry and was admitted to hospital would be sufficient. The mental element would be intention. It would be argued by Michael that he did not possess the relevant intention as he only did it as a joke. But based on what Rhodes suggested, we could argue on the fact that he went beyond by appearing in front of Stephanie out of breath and red in the face when telling about Ahmed, therefore showing that he had the necessary intention to cause harm to Stephanie. However, the main hurdle or the main issue in this case would be the consequence element, as it was stated in the case of Rhodes that it must be a physical harm or a recognized psychiatric illness, and that mere distress would not amount to it. With that being said, Michael would argue that since Stephanie only suffered a panic attack, which is somewhat similar to emotional distress, would relieve him of any liability. Now, to tackle this argument, it is essential for Stephanie to show that she suffered or there was some form of recognition of psychiatric illness, which was caused by Michael's action, and that this would be prevented if it's not for Michael's action, therefore allowing her for a claim. The next argument which would put the next argument to be put forward would be to ask the courts to adopt a new tort, namely the intentional infliction of emotional distress. Now, Lord Neuberger in the case of Rhodes mentioned that it should be enough for the claimant to establish that he suffered significant distress as a result of the defendant's statement, thus showing that Lord Neuberger was lenient towards the consequence element which was established in the case of Rhodes. Furthermore, in the journal article of Wilkinson and Downton Revisited, Chris Hunt criticized that the courts went too far in narrowing the tort scope by not considering more fully of what Lord Hoffman suggested in the case of Wainwright, that severe distress short of harm should be actionable. Looking at both Lord Neuberger's statement and Lord Hoffman's statement, it shows that judges are inclined to create a new tort but are approaching in a more cautious way, as it could be argued that creating a new tort would lead to a floodgate of litigation. However, looking at other common law jurisdictions where the rule of Wilkinson was adopted and further developed, such as the United States of America and Canada, this could help us understand and even help us create a new tort. In the United States of America, under Section 46 of the Restatement of the Law, Tort Liability and Physical and Emotional Harm, 2012, Volume 2, it stated that an actor who by extreme and outrageous conduct intentionally or recklessly causes severe emotional harm to another is subject to liability for that emotional harm, and if the emotional harm causes bodily harm, also for the bodily harm. Now, in that commentary, it was mentioned that the courts have played an especially critical role in cabining this tort by requiring extreme and outrageous conduct and severe emotional harm. A great deal of conduct may cause emotional harm, but the requisite conduct for this claim, extreme and outrageous, describes a very small slice of the human behavior. The requirement that the resulting harm be severe further limits claims. These claims are essential in preventing this tort from being so broad as to intrude on important countervailing policies, while permitting its judicial use for the occasion when it is appropriate. Furthermore, in Canada, it is settled the law that the tort of intentional infliction of mental distress or shock has three elements. The first element being that the act or statement has to be extreme or outrageous. The second element being it's calculated to produce harm. And third, that the statement causes harm. Therefore, by looking at other common law jurisdictions, it can be argued that the UK court should adopt a new tort of intentional infliction of emotional distress. Although the courts may argue that since we have the Protection of Harassment Act, which provides a remedy and damages for a cause of conduct amounting harassment. However, it is to note that there must be a cause of conduct which is needed to be established, which is usually more than once, thus showing that Parliament was conscious that it might not be in the public interest to allow the law to be set in motion for one incident. Therefore, by adopting a new tort of intentionally inflicting emotional distress, it will act as a backup for the Harassment Act and possibly close the gap between the recognized psychiatric element and the severe emotional harm element. Not only that, it allows claimants such as Stephen to succeed in their claim where the only harm that they received was emotional distress and not a recognized psychiatric illness. Furthermore, by allowing a new tort, it also established justice, which is the backbone of our legal system. Thank you.